Access to Democracy is made possible by donations from the following organizations. Thomson Reuters, a global company with expertise and insight to unravel complex situations in the areas of law, tax, compliance, government, and media. Their worldwide network of journalists and editors keep customers up to speed on relevant global events. Thomson Reuters, the Answer Company. The Division Championship Minnesota Twins are looking to go all the way to the World Series in 2024. Bolstered by inspirational shortstop Carlos Correa, a healthy Brian Buxton, and rookie phenom Royce Lewis, plus a pitching staff led by Pablo Lopez and an outstanding bullpen featuring Johan Duran, the Twins are the best bargain in the major leagues, and Target Field is the best venue in baseball. Sheridan Dulas & Kins, PA, a family and criminal defense law firm, has been serving clients in Dakota County and throughout Minnesota for over 40 years. Ranked a Tier 1 Best Law Firm by U.S. News and World Report every year since 2009, Sheridan Dulas & Kins are here to help you in your most difficult life circumstances. Established in 2007, 45th Parallel Spirits was among the first 50 micro-distilleries in the United States. Based in New Richmond, Wisconsin, all aspects of production occur at our facility. If you're interested in visiting and learning more about the 45th Parallel Distillery, please check our website and plan a visit to tour our facility and taste our spirits. Truestone Financial, with locations in Minnesota and Wisconsin, has proudly served its members since 1939. Truestone engages, educates, and supports its members to ensure they have the tools to empower their financial well-being. Truestone Financial, your neighborhood credit union. Learn more at truestone.org.
Hello and welcome to another edition of Access to Democracy. I'm your host, Steve Francisco. Thank you for joining us on this beautiful summer day here in Minnesota. Today we have a return visitor to Access to Democracy, our resident expert on law and American politics, Professor David Schultz of Hamline University and the University of Minnesota Law School, my alma mater. David, thank you for joining us today.
Always my pleasure to be on this show.
So there is a little bit of news these days about the state of American politics, and perhaps one of the biggest questions hanging over all of us right now as we record this show on July the 12th is President Joe Biden in fact going to end up the nominee of the Democratic Party to face off presumably against Donald Trump, the nominee of the Republican Party? You have an article in the MinnPost online newspaper, which was published today, saying that you believe there's an ethical problem with Donald Trump and Joe Biden as presidential candidates. Tell us more.
Right. And what it is that one of the things that I've learned over the years doing training, ethics training for lots of organizations, is whenever somebody in a position of authority says to me, this organization couldn't exist without me, I say to them, it's time to leave. Because what you've done is failed to demonstrate an ability to separate out what's in the best interest of the mission of the organization versus what's in your own personal interest. And the reason why I mention this, clearly all along, we've known this as a problem with Donald Trump. Going back to his acceptance speech in 2016, where he said, only I can solve these problems, only I can fix America. We always knew he had a problem, and his presidency demonstrated that. But Joe Biden, in both his interview with George Stephanopoulos, a week after the debate, and in his press conference, the NATO press conference, demonstrated that also. Seemed to indicate that only he, of all the people in America, could address and fix the problems that he saw in America. And for both of them, it's become what? Running for the presidency is just about them. It's not about what's in the best interest of the country, the world, or the party. And that's what my argument was, is to say, when they're in a position of this inability to separate out their own personal interest or ego from the greater good, walk away.
Neither of them are meeting the test, in your opinion.
Correct.
It seems that a real telling moment following the debate came when President Biden made the statement that, in effect, he thought he was the only one
Yes.
who could defeat Donald Trump in 2024,
Right.
which is very similar, as you point out, to comments Donald Trump made when he ran both in 2016 and in 2020, losing to President Biden, when he said, I'm the only person that can save America. I'm the only person that can get the job done. Yeah. That was very troubling.
It was troubling. Troubling on that score, but troubling on a different score also, in the sense that I don't think he still has yet, again, as of July 12th, grasped the degree to which the debate was an absolute debacle for him. You know, going into that debate, we had large percentages of the American public, including large percentages of Democrats, who were saying, we're not sure about his mental acuity, his ability to really stay on and run for the presidency. And in that debate, he did nothing, absolutely nothing to help himself, and in fact made it worse. And then after the debate, at one point, he supposedly said, well, I don't think that went so badly at this point, or I did it really well. But the fact that then, a week later, to me, this is what really cemented it for me, in terms of the question about his mental competence, is when he was doing the interview with George Stephanopoulos, and Stephanopoulos asked him, did you watch the debate afterwards?
Right.
And Joe Biden said, I can't remember. Something that important.
And we've never seen this. We've seen presidential candidates. I mean, you and I recall, even in 2012, Barack Obama's first debate with Mitt Romney didn't go as well as he had hoped.
It was horrible.
But we're sort of in unprecedented territory, aren't we? Where a presidential debate, there's been such a disastrous result that potentially affects President Biden's ability to stay in the race. Are you concerned as well by the fact that while the Democrats have become obsessed the past 2 weeks about does Biden stay at the top of the ticket, Donald Trump has essentially had a free pass to run around the country continuing to spew a lot of mistruths and falsehoods, and including denying that he knows anyone associated with Project 2025, which is a Heritage Foundation suggested blueprint for what a next Trump administration might do. Are you concerned about that too?
Well, I'm very concerned about it, and also about the fact that people who are connected with 2025, I think there's been at least over 100 people who have worked for Trump who are involved with that organization.
He says he doesn't know them.
Well,
he doesn't know Stephen Miller. He doesn't know Peter Navarro.
Yeah. Well, he's never known anybody that he's been found guilty of also in terms of some of his criminal charges. Or Jean Carroll, he said, I never met her, even though a jury found him liable for defamation. What I'm getting at here, he is a liar. He is a pathological liar. And he's getting a free pass right now because the focus is on Biden, and the focus is on Biden's, again, mental acuity or cognitive capacities. And the Democrats have started to realize that Biden is a distraction for them being able to beat Donald Trump. We still are not at a point yet where Joe Biden or his inner circle is at that point of realizing it.
Would you agree there's a qualitative difference, though, when we talk about somebody being unfit for the presidency? Donald Trump has been convicted of 34 felony criminal conviction, is still facing criminal charges pending in federal courts and in state courts. And just the mountain of legal problems that he is facing in terms of this, we still don't know what his sentence is going to be in the New York case.
No, you're absolutely correct. There's a qualitative difference between the two of them. One of them, I'll just say, never was and never should have been elected president, and what never was and still is not qualified to be president of the United States. Does not understand an iota of what it means to be the chief executive or president of the United States, doesn't understand what it means to represent a country that has an important role in democracy across the world. The problem with Joe Biden is different. All of us are going to say that he served his country well for 50 years, that he has actually had a consequential presidency, incredible amount, but something happened. And I want to tell you a great story here, is that we all remember when Biden was running the first time, he said, I'm a transitional president. Okay. I've got a book that just came out recently on generational politics, but it's been in production for a while. In approximately November of 2022, after the midterm elections, I get a back channel call from the Peter Buttigieg campaign. And they want to know if I would talk to him about what we learned about generational issues. And I said, why? And they said, Peter Buttigieg, the person I was speaking to, said, is going to step down from the Secretary of Transportation very quickly and declare he's running for President of the United States. And that was at a point when all of us were still thinking Biden's a one-termer. Mm-hmm. Something happened. I never had that meeting because by January, Biden said he's running. So what's happening here is somewhere along the line, November, December, early January, going to January 2023, Biden changed his mind and caught everybody by surprise by saying, I'm going to run again. None of us ever expected that. All of us thought, as he said, I'm merely a transitional president.
And back to your earlier point, Dave, and the point of your MinnPost article today, politicians get confused. It's really not about them. It's about the people that vote for them, what their dreams are, what their aspirations are, and as far as the politician goes, what your ability is to carry out their agenda. Isn't that true?
That's the theory of representative democracy.
That's right.
That's what's supposed
Always has been.
Always has been. And so in some sense, for Biden, there are other people. Mm-hmm. There are other people who might be more able to carry out this agenda. Again, the agenda that Biden had wasn't Biden's agenda alone. It was the people's agenda. It was the people who said, we want you to do X, Y, and Z.
Right.
And it's possible that whether it's Kamala Harris or somebody else, they are equally capable of doing this. I want to make one other point, one other story here, story days, is that I had a conversation recently with somebody in Minnesota who's a Biden delegate to the convention. Mm-hmm. And I was asking him what his thoughts were. This is all obviously off the record. And he said, if I knew now, or knew then rather, what I know now about Biden, I wouldn't have pledged for him. And he said, I think I committed to him under false pretenses, thinking that his cognitive capacities and his abilities were something when they're not. And the reason why I mention this is that on one level here, the only way Biden is out of the race is if Biden says, I'm not running and I release my delegates. I want to propose a different theory. I want to propose a different theory that says that for many of those delegates who might now have buyer's remorse, who are worried about the fact that they didn't know about his mental acuities then, I think you could make the argument and say they made the pledge, they made a commitment under false pretenses. And I think you could make an argument that says that they should be free on the first round to vote on their conscience and vote based upon what they know now.
We should remind people, too, there was a candidate in the Democratic primaries, Minnesota Congressman Dean Phillips, who ostensibly ran on this issue of Biden's age, saying he's going to be too old to serve again. He got, what, 1% of the vote in the primaries that he got into, won essentially no delegates or very few delegates to the convention, and dropped out of the race.
Yeah, his was the
So there was an opportunity at that point, it would seem to me, if people were aware and were concerned about it, that was an alternative at that time, but we're way past that now.
Yeah. He was a classic shooting the messenger.
The
message was
people
right.
didn't want to hear it.
Yeah, he had the right message. He was the wrong messenger
to
at
deliver
that point. And I don't know who would have been the right person, but it needed to be somebody more than a third-term congressman.
Yeah, we need to transition here, David, to what has been arguably one of the most consequential Supreme Court terms that we have ever seen in American history. A raft of decisions came down, fundamentally, and many of us would argue radically, changing American law. I want to start off asking you about the so-called immunity case, Trump versus United States. The Supreme Court ruled 6-3. Remember that number, folks, 6-3. You're going to hear that over and over again. A 6-justice majority against a 3-justice liberal minority.
And 6 justices appointed by Republicans.
And 3 of them appointed by Donald Trump.
Correct.
Including, in this case, nobody recused themselves from the cases, even though they were appointed by him. But they ruled that former presidents are immune from prosecution for official actions taken while in the White House, but do not have immunity for unofficial acts. They basically remanded the case to the district court, Judge Chutkan, who has to determine which acts were official and immune from prosecution, and which were unofficial, and they leave him subject to prosecution. So what happens with the January 6th case against him?
It doesn't go anywhere before the election. The Supreme Court basically decided without deciding anything. What they decided is what? Trump's not going to face trial before the election. But did they give us any type of guidance, any type of direction in terms of what's official versus unofficial? No. Justice Sotomayor, in her dissent, first pointed out the fact that there was no need to say presidents enjoy absolute liability whatsoever. You did not need to have that. All you had to decide in this case is, could the case go forward? But they created this illusion that goes against text in history. And I say that because nothing in the Constitution says presidents have immunity. And if you go back to the Constitutional Convention, Alexander Hamilton himself says, guess what? Presidents can be prosecuted afterwards. Benjamin Franklin says this. Additionally, the clear text of the Constitution in talking about impeachment says that what? Nothing in impeachment precludes prosecution afterwards. So for a group of justices who claim to be originalists or textualists, they forgot originalism, they forgot textualism. It was results-oriented jurisprudence. And Justice Sotomayor points that out, but she also says that, guess what? Based upon what the court has said, it's still not clear if a president orders the assassination of a political opponent. Is that an official or unofficial act?
That's a stunning thing to say.
Yes.
And I thought the people who founded our country, and here our country, if we can make it to 250 years old as one of the world's oldest democracies, that we created this country to get away from the idea of kings and people who had absolute rule.
I'm glad you said this, because one of the things that I tell my students when I teach, I write the word on the board, fear. And I said, our country was birthed on fear of abuse of power. If you read the Declaration of Independence, all of us know the first two paragraphs. When in the course of human events, we hold these truths to be self-evident. The second half is an indictment against the King of England of all the horrible things that we did.
All of the usurpations and abuses,
Exactly.
the list, right?
Our country was birthed on a fear of absolute power in executives or kings.
And we created a judiciary to protect these rights, but it just seems like, and I've heard many people use this term, they are describing what we are witnessing as nothing less than a judicial revolution.
Yes.
A radical interpretation of the Constitution that actually is accumulating power to the judiciary to decide these issues. Do you agree with that critique?
I do. I do at this point, because I've been flirting with writing a piece that's called The Coming of the Second Lochner. And what I mean by that, Lochner versus New York is a famous case from the beginning of the 20th century where the Supreme Court basically says, we're going to second-guess legislatures. We don't think minimum wage laws, we don't think workplace safety conditions are a good idea in New York. We're going to take it upon ourselves to make these choices here. What the court is now doing is acting as a super legislature. It is, what, 6 justices acting as politicians with robes.
And to remind people, these justices of the court, they are unelected, they are appointed by presidents, they serve for life.
That's right.
They have a life term, not subject as our senators and Congress people are to the will of the voters at every election. That's a good transition, because I want to ask you about another case which I think has gotten very little attention, or not nearly as much as it should, because it has huge implications for every living American man, woman, and child. The court overturned something called the Chevron Doctrine. This was a very important case, and it basically said that courts will give broad discretion. Well, the Chevron Doctrine said that courts would give discretion to agencies in promulgating rules and regulations. Because think of it this way, agencies such as the EPA, they would know better than Congress about setting standards for air quality.
That's right.
OSHA would know better than Congress about setting standards for workplace health and safety. But in this case, they have trimmed that and taken it away and basically invited any corporation or business to sue against these agencies and say, you didn't have authority to do this because Congress didn't do it.
That's right.
Where does this lead us?
Well, this is the really great question here. This is a major assault upon regulatory agencies in the United States, especially upon the EPA. If we had time, we would talk about some of the other cases this semester where the court trimmed back on the ability of the EPA to regulate in terms of emissions and a whole bunch of other things. But certainly the implications of this are going to be played out over the next several years, where agencies are going to have their authority trimmed back. And going back to thinking of the court as a super legislator, it's going to set up the Supreme Court to say, well, we don't agree with the EPA's determination here. Again, one of the things I say to my students, my law students sometimes, when I used to talk about Chevron deference, because I taught administrative law, I would half kid but be half serious and say, we're just a bunch of dumb lawyers. What do we know about air quality?
Right.
What do we know about...
But you have scientists who have expertise.
Right, and that's what you're supposed to do. The court is supposed to say, we don't know, we're just a bunch of justices, we know the law, we don't know air quality, we don't know what is clean water, what's clean air. Let's defer to the EPA.
Let's be very clear about something too, David, and I'm thinking back 40 years to my days as a law student at the University of Minnesota, where you teach.
Yeah.
I remember administrative law, and I remember the concept of deferring to administrative agencies, but I also remember it doesn't leave corporations or businesses or citizens without any right to sue.
That's right.
If an administrative agency is arbitrary and capricious in the way that they issue regulations or enforce, they can be sued. Chevron didn't prevent that, but what the court is doing now is coming in and saying, we're going to substitute our judgment for OSHA, the Occupational Safety and Health Administration, the Department of Labor, the Environmental Protection Agency. How is that going to be good for the American people who need protection in their health and safety?
Well, it's not going to be
protecting our environment.
It's not going to be good for them whatsoever. It's basically what? It's part of a broader, I'm going to argue, neoliberal or conservative agenda to trim back on government regulation, to basically capitulate to what? Corporate power and corporate interests in America. And I'm not against corporations. I'm not against them at all. But there are times where what? The marketplace and corporations need to be regulated both to protect people and what? I'm going to argue even to protect corporations against their own self-destructive behavior.
I think many people would argue, if you look at the American economic model, we have had a successful, largely successful mix of what I would call regulated capitalism, not unchecked, unregulated, rampant capitalism. But this brings us back to a situation where the court's decision is basically handing an awful lot of power to businesses to sue so that they can do what they want.
Thus, again, for people who went to law school, the second coming of Lochner versus New York. We're going to go back to this fiction of the pure free market.
Yeah. I want to ask you about a couple of other cases here, too. In the area of abortion, the ground is still settling from the court's earthquaking decision of 2 years ago when they, in the Dobbs decision, they basically overturned Roe versus Wade, which had been settled American law for 50 years. Basically saying that in the first trimester, it's a woman's decision alone whether or not to terminate a pregnancy. The government's interest increases going to the second and third trimester. So there was an important case that came up about the abortion pill, mifepristone. And actually on this one, this case stood out because it was a 9-0 ruling maintaining broad access to this abortion pill. It turns out that about 60% or almost 2/3 of all abortions in this country or pregnancies are terminated using this pill. But certain states were moving to prohibit the use of that. What was your reaction when you heard about this? And are you surprised that it was a 9-0 majority that said, no, we're going to protect women's right to access this abortion pill?
Well, technically, they didn't decide the case on the merits. What they said is that the physicians who were bringing the case, you were the wrong people to bring it.
Didn't have what's called standing. Right.
Go leave and leave us alone. And the reason why I say this is that it doesn't mean that a group of people in the future can't bring this case again who have standing and challenge it.
In fact, in the majority opinion, I read part of it, and they all but invited some other party someday to come back to the court.
That's right.
Another party, they didn't rule out the possibility that anyone could have standing. So, it raises the scenario that some of these protections or freedoms that women have in terms of reproductive freedom and women's health care, they're only safe until somebody at the Supreme Court overturns them, as they did with the Dobbs decision.
Yeah, basically what you have now is, I'm going to say 6 justices. 6 justices are deciding roughly 150 million women could do with their bodies.
I want to ask you about a case that a lot of people were watching, City of Grants Pass, Oregon versus Johnson. The city of Grants Pass was challenged because of laws banning homeless people from sleeping in public spaces. And the people challenging the law said it was a violation of the 8th Amendment's prohibition against cruel and unusual punishment, that they were saying you couldn't criminalize a status of being homeless. The court ruled against them, again, that number 6-3, and they said, yes, that regulations banning people, homeless people with nowhere else to go, were still valid. But interestingly, the court didn't say that local communities had to ensure that there was adequate shelter to get people off from the street. What was your reaction to this case?
This is one of the most cruel decisions that I think this court has issued in years, because it's basically taking people who are oftentimes, down and out on their luck, have no place to go, have to basically sleep in their shoes on a street or wherever it is, and say, guess what? We're going to criminalize your bad fortune. Again, if I think of a whole different concept here, doesn't somewhere along the line our Constitution say you can't put debtors in prison? This is kind of like punishing people that way and saying that we are going to punish you for your misfortunes in life, things that are beyond your control. You're on the street. We're now going to arrest you.
But not requiring in this case, the city of Grants Pass didn't show, as I recall, that they had adequate space.
That's right.
To house people that you were saying can't sleep in a public park.
That's exactly.
And we understand if you go to Los Angeles or San Francisco or Seattle, walk down the streets, Minneapolis, any major city, you will find encampments where you have people who have nowhere else to go.
Yeah.
But if you're not going to guarantee that we have places to put people, but we're still going to say cities can have regulations that criminalize you being out there sleeping overnight, where are you going to go?
You have no place to go. See, I actually would go further. What I mean by that is, even if a city provides shelter, even if it had an alternative, I still think it's wrong to criminalize and punish people if they opt to sleep on the street.
So you agree with Justice Sotomayor, who said, in fact, yes, what the court did was to criminalize a status, namely the status of being homeless.
Exactly.
That's what she said in her dissent.
She did.
We've got less than 2 minutes. I want to ask you real quickly about another case. There was some action on the issue of guns this year. The Supreme Court struck down a ban on bump stocks to guns. Again, there's that number, 6-3. The majority struck down a federal ban on bump stock devices that allow semi-automatic rifles to fire hundreds of bullets a minute. What was your reaction to this case?
Well, this goes back to the case we talked about with Chevron.
We've got only a little more than a minute.
Right, and I say that because what the Supreme Court said here is that Congress had defined a machine gun, and when the president issued an executive order, remember the president was Donald Trump, by the way, and said...
After the Las Vegas mass shooting.
Yeah, and said that putting the bump stock turns it into a machine gun. The Supreme Court said, no, you guys don't understand what a machine gun actually is, and you don't understand what a definition is. I would beg to differ and say, I think we ought to defer to a regulatory agency if they think putting certain equipment on a gun turns it into something that looks like a machine gun.
That can kill hundreds of people in a matter of seconds.
They're the technical experts. Let them make that decision.
Yeah. And we'll mention real quickly, we're down to just a few seconds. There was also a decision, 8-1, the court ruled that a federal law that bans people who are subject to domestic violence restraining orders from having firearms, they upheld that. David, as always, we never have enough time.
That's right.
We need to get you on for a 1-hour show sometime, especially at the end of a Supreme Court term. Hamline University, University of Minnesota Law School professor David Schultz, thank you for being our guest again on Access to Democracy.
My pleasure. Thank you.